Don't be silly.
Guys, we've got us first.
Don't be silly.
Need my permission.
No.
No, yeah, do it.
So you could
get close to me again, like back off and get out of my first one's place now. Sir?
Today, we're going to explore some of the archaeology of auditing. No, not that kind of archaeology. I'm talking about some old content on YouTube in which we can see one of the early influences on Marti Blagborough at work, an auditor called David Birdsall. An older man, he gave Marty some of his ideas about the law and photography rights and taught him some of the methods of auditing. And you know what they say, the apprentice bests his teacher. Seems that Mr. Birdsall didn't have any problem with using a phone while driving, which is an offence, contrary to Regulation 110 of the Road Vehicles Construction and Use Regulations 1986 and Section 41D of the Road Traffic Act 1988. Would it be permissible for me to audit Mr. Birdsall's driving habits? He seemed keen enough in these videos to go around making judgments about other people. Well, let's turn the tables on him and look at some of his auditing. One of the earliest auditors, now forgotten, I think David Birdsall's first audit video was filmed in 2018, and you're looking at it now. Here's another audit he did, this time a public building. He was a rude and entitled man who liked making vexatious and ill-founded complaints. Some of his complaints may have been well-founded, but he helped set in place this trend of acting like a spoilt toddler towards official people and authority figures while calling yourself an auditor. It's not all the fault of auditors themselves, though. Their behaviour is foul, but I think we also have to acknowledge that this trend was given fuel by the hysteric overreaction to COVID-19 from the government and the clumsy, heavy regulations that they brought in. What my video is going to do is look in depth at a particular collaboration between David Birdsall and Marti Blagborough.
Hi guys, welcome back to the channel, or welcome to the channel if it's your first time around here. So we're out and about in Leeds today, and I'm not on my own, guys. I'm not on my own. I told you it would come in 2019. So I have with me today, we have Dave. This is Dave, everyone. He's come down on a travel to come see us, to come help the cause. So we're going to check about Leeds. We're going to see a few people. We're going to hit a few audits. We might be heading out of the city as well later on. I'm not going to keep it rolling all day long. We're going to keep it simple. I'm just going to get the camera on when we've got some sort of interactions going, and we will check back with you very soon.
This happened in Leeds in 2019. They harassed a jewellers called Berrys, but I'm going to include some footage from just before that point, still in Leeds.
So guys, we're just here in Victoria quarters, just having 2 minutes with there was a security guard having a little look over at us. I don't know if he's going to approach us, but I guess we'll find out in a minute or two. Whew. So guys, we're just here in Victoria quarters, just having 2 minutes with there was a security guard having a little look over at us. I don't know if he's going to approach us, but I guess we'll find out in a minute or two.
Yeah, he didn't bite.
No, he didn't bite.
Damn, he didn't bite.
Guys, he's been triggered.
But he didn't bite that time.
Yep, here we are in Leeds. We're out fishing. Oh, we're out fishing, so I'll have to edit that bit out. And there is Marty.
Hi guys, welcome to Dave's channel. I hope you come again.
They will. Build it and they will come.
That advice certainly worked for Marty. They then proceed to Berrys, and here's what transpired.
Why is there two?
Excuse me, just ask why you're taking pictures of the window?
Because we can.
So if I came and took a picture outside your house, you'd be happy with it?
Whoa, keep this into context. This is a business.
We have to be
This
very
is a
careful
business.
because we've had armed robberies and things.
I would not come out of your house and take a picture. So don't even go down that
I
road.
just came out and politely asked you why you were taking a picture, that was all.
Because I can.
Because he can. There you go. The jeweller's front's a public thoroughfare. There's nothing illegal in and of itself in photographing a shop, obviously, but the point being made by the staff member is that two strange men turning up to photograph a shop display of expensive stock is a cause for concern. David Birdsall's reaction is to start getting mouthy and clever, which does no good whatsoever for photographers in general.
Because he can, but don't come that, 9/11 stuff, and if I was living outside of your house, it just doesn't work.
Alright, okay.
Watch.
Brilliant. Amazing. I'll take a picture of you then, it's fine.
Of course you can.
You were at work, so we have a right to fire request any pictures you take of us. You were at work at the company, we can make a fire request.
Whatever.
Yeah, get back inside then, innit?
Pardon?
Get back inside then, innit?
Not being rude.
You were rude.
I came out and politely asked
You were rude first.
I wasn't rude.
Yes, you was.
No, it was a polite conversation until you started mentioning homes.
You can see that David Birdsall ignored the objection and just carried on taking photographs and recording.
But you brothers, you're at work, so we have a right to fire request any pictures you take of us.
Pardon?
You brothers, because you're at work at the company,
Well,
we can make a fire request for that.
Whatever.
Yeah, get back inside then, innit?
Pardon?
Get back inside then, innit?
Not being rude.
You were rude first, buddy. You were just rude first.
Maybe where he's from, guys, saying whatever and shaking your head while someone's talking to him walking away isn't rude.
It's all going off in there, though. It's all going off. Have you seen them all? Huh? They're all coming for a little look-see now. Yeah. Look at them all. Have I got a card?
The security guard comes out now.
Security, he's ready to come out. He needs to find out what's going on.
What was he doing there? Was he being...
Showing you his SIA badge.
Oh, right. SIA badge.
See that, guys? This is Berrys in Leeds. Berrys in Leeds. Apparently that's how we treat it.
Huh? Are there?
Please. Right, the reason we don't do this, we don't have pictures taken in the building. Hold on. Do you understand?
I'm not a robber, though.
I don't know. It don't make no difference. You can pass the information to somebody else.
Well, I'll be posting.
then-
I'll be putting the footage on YouTube later. Yes, I will be.
Without permission, I used to work for.
I will be putting it on YouTube, and you cannot stop me.
To Marti Blagborough's credit, he does state what is going to be done with the footage, albeit in general terms.
There you go. You can watch it later.
I don't know what all the shushing is for. He's a very annoying man, is David Birdsall. But anyway, Marti Blagborough even gives them a business card.
I used to work for.
I will be putting it on YouTube, and you cannot stop me.
You can actually.
There you go. You can watch it later.
You can.
Really?
Yes, I can.
There's nothing really more to say.
Yeah,
We can
but
take... No. We're not robbers. We might be robbers. You might be a robber. We aren't robbers. You aren't a robber. It goes round and round in a circle. Right? If you automatically come from the point of view that we are robbers...
I have the card. All right then.
Yeah?
But
Relax.
but it's not funny.
Who said it was funny?
How many times has this place been robbed?
Who said it was funny?
No. How many times has this place been robbed?
Do you have insurance? Do you have insurance?
Why
are you telling me how many times you've been robbed? I don't know. I'm not interested. But are you insured?
May I ask why that you've taken footage? Why are you taking
Of the watches?
Why are you taking film of us as well?
Yeah, because you were looking at me like, what you're doing? I'm doing nothing wrong.
Yeah, but
You're doing nothing wrong. Let's go back to what you and Marty said earlier that same day.
So, guys, we're just here in Victoria Quarters, just having 2 minutes with there was a security guard having a little look over at us. I don't know if he's going to approach us, but I guess we'll find out in a minute or two.
Yeah, he didn't bite.
No, he didn't bite.
He didn't bite. That's what this is really about, getting a reaction from people.
But the whole thing is, the whole idea, we deter robbers from this place.
No. Do you think if we were robbers, we would stand here taking pictures?
We're just doing a bit of pre-arrangement before we rob the place. You know what I mean, guys? We're just casing the place.
Well, you might be. Some criminal gangs do carry out surveillance before they rob a place, and from the point of view of the staff here, they don't know who you are. I know you've given them a card, but they don't know that's genuine. Nobody is suggesting, just let me emphasise, that it should be illegal to record in a public place, including recording the frontage and stock on display of a shop, even if the staff object. But motive and purpose is a crucial point here. The purpose of David Birdsall and Marti Blagborough is to provoke a reaction, which is why the two of them are being so opaque about what they're up to. Albeit I must give Marti Blagborough some credit because he did provide a business card, but they've not given an explanation. And the reason for this is that their true purpose is to provoke reactions.
What's this mentality?
We're just doing a bit of
it's wrong.
No, it's not. It's called freedom.
We're just casing
Pictures which you take in public is not a crime. It's not a law where you can say...
You're taking pictures of the building?
Yeah.
Right.
Anything you can see with these eyes. See the cameras there? Watch. So now I go like that. Take a picture. Your security camera, and you've got another one there. There's about another 80 along here.
But we don't need you to prove that we have that liberty. Everybody knows, or should know, that as a general principle you can take a photograph of a building in public even without the owner's consent. I think the issue the security guard has is that he objects to this particular behaviour of these two men. I assume that if this was a couple of genuine photographers, there wouldn't be the same issue because if concerns were raised, they would diffuse the situation and explain themselves.
What really is it making any difference to my life or your life?
People.
No, you don't deter robbers.
What you're doing right now is impeding our rights.
No,
you
not
are.
impeding
You're
your
being
rights.
a tyrant.
You are.
You are. You're a tyrant.
Why am I being a tyrant?
According to the Collins Online Dictionary, which is pretty liberal in its usage, a tyrant can be any one of the following. 1. A person who governs oppressively, unjustly, and arbitrarily. Despot. 2. Any person who exercises authority in a tyrannical manner. 3. Anything that exercises tyrannical influence. 4. Especially in ancient Greece, a ruler whose authority lacked the sanction of law or custom. Usurper. This situation would seem to come under the second of those definitions. Any person who exercises authority in a tyrannical manner. That definition seems circular to me, but if we rely on the first definition to support it, then what it seems to be saying is that the word tyrant can be used figuratively to refer to anyone in a position of authority who acts in an oppressive, unjust, or arbitrary manner. We know this security guard is not acting in an arbitrary manner because he's raising objections to the photography and filming for a reason. And we know that he's not acting unjustly because we know what Marti Blagborough and David Birdsall are up to. Therefore, his actions cannot be oppressive either. I would take a different view of it if he were objecting to the activities of genuine photographers. But there again, a genuine photographer wouldn't behave like this.
Because, you see, we have the right to take pictures in a public place. Fact.
Absolutely correct, and I would never question that right. The problem is that you're not exercising that right. You're there to get a bite, remember?
So, guys, we're just here in Victoria Quarters. Just having 2 minutes with there was a security guard having a little look over at us. I don't know if he's going to approach us, but I guess we'll find out in a minute or two.
Yeah, he didn't bite.
No, he didn't bite.
I accept that the two motives can go together, but as I've already pointed out, the right to photograph in public is not in question. You're not really proving anything here beyond that the staff at a jeweller's get nervous when people start taking photographs of their stock, which is only to be expected. This isn't a big human rights case. It's not that your freedoms are under threat. It's just an ordinary mundane situation that requires a bit of common sense.
Of the actual building?
Of anything that my eyes can see. For as long as my feet are in a public space, then I have the right to take pictures or video, and I also have the right to do whatever I want with that footage.
Do you have a phone?
Again, what Marti Blagborough has just summarised there is generally correct, though I think he does go a bit too far when he says he has the right to do what he wants with the footage. For one thing, there is data protection to consider, something that you already know that neither David Birdsall nor Marti Blagborough have ever considered, unless of course it's their own data protection rights, then they suddenly become quite knowledgeable.
Do you have a phone with a camera?
Because if you think about it, buddy, logically,
Yeah.
if I wasn't allowed to do this, you wouldn't be allowed to do that.
That may be logical on Marty's part, but logic does not always lead to the right answer, especially when the process of logic omits some key information, such as the fact that data processing for the purpose of site security and crime prevention is permitted, and implied consent is given to this by anyone within the store or approaching the store. If David Birdsall and Marti Blagborough want to stand outside a jeweller's while filming and taking photographs of the frontage and expensive stock, as well as recording the staff, then you can expect that the store will take an interest in them, capture images of them and approach them.
We've got a license for those, haven't we?
You don't have a license for CCTV. You don't need a license for CCTV.
You need a license to operate and function.
No, you don't.
It's up in the air a bit as to whether a licence is required for the operation of CCTV. In simple terms, an SIA licence is required for public space surveillance, which is any CCTV activity that goes beyond simply guarding premises and property. This is known as a public space surveillance licence. The question is whether the surveillance outside a jeweller's is behavioural or just amounts to guarding of the premises and stock. It's a matter of opinion, really. It's something we don't really need to go into on this occasion. Businesses with CCTV do also have to abide by data protection and also have to be registered with the ICO as data controllers. That's Regulation 2 of the Data Protection Charges and Information Regulations 2018.
You need a license to operate and function.
No, you don't.
He's not being silly at all, and depending on the exact use of the CCTV, he's potentially right. Auditors don't need a licence, of course, but data protection does also apply to auditors. Not that they ever take any notice.
Don't be silly.
Guys, we've got us first.
Don't be silly.
Need my permission.
No.
No, I don't.
So you could
Get
keep
close
it.
to me again, like back off and get out of my personal space now.
First of all, he's not stood in Marti Blagborough's personal space. As you can clearly see, he would have to be stood much closer for that to be the case. Second, if they don't have his permission to record him and they're recording his face, then he could object on privacy grounds through the complaints process of a social media platform and ultimately through the courts, because he is, after all, outside his workplace and he is performing his work duties in challenging David Birdsall and Marti Blagborough, who have not turned up just as genuine curious photographers. They have turned up to get a bite, to cause trouble.
Back off out of my personal space now.
You can clearly see that the man is not in Marti Blagborough's personal space. Marti Blagborough is lying in order to create drama for his viewers to watch.
Thought it was a free town, sir.
Back off
Back
out
off.
of my personal space.
He's still not in Marti Blagborough's personal space. Marti Blagborough is the one who's shouting and causing a scene. Now let me show you the same interaction from the camera of Marti Blagborough himself.
Guys, we've got us first.
You can see straight away that from this angle the individual can be made to seem more aggressive, and it looks like he's standing close to Marti Blagborough. We know from the other camera angle that he wasn't standing in his personal space and he wasn't being aggressive. They say the camera never lies, but that's not true. This is an example of how cameras can be used to present a misleading and manipulative impression of a situation. You'll also have noticed how Marti Blagborough has suddenly become very aggressive and has no compunction about lying and creating a false picture for his viewers.
You've now broken the law.
Who's broken?
You.
Personal space, you know what it is? It's free
Harassment.
foot. It's free foot.
That is harassment.
I think that's preposterous. I think if anybody has committed harassment here, it's the auditors. Let's consider what harassment means in England. It's defined in the Protection from Harassment Act 1997. Section 1 of the Act prohibits harassment. Subsection 1.1 states that a person must not pursue a course of conduct that amounts to harassment and which he knows or ought to know amounts to harassment of the other. Subsection 1.1a states that a person must not pursue a course of conduct which involves harassment of two or more persons and which he knows or ought to know involves harassment of those persons and by which he intends to persuade any person, whether or not one of those mentioned above, not to do something that he is entitled or required to do, or to do something that he is not under any obligation to do. What we have there are two separate offences of harassment, subsection 1.1 and subsection 1.1a. The subsection 1.1 harassment offence covers harassment of a single person. When I say single person, I don't mean that the person has to be alone in the situation or that where there are multiple people only one allegation can be made. I just mean that the allegation would be of harassment of that one person. The offence could still be charged multiple times if there are multiple people. Meanwhile, the subsection 1.1a harassment offence covers harassment of two or more persons. Section 2 of the Act states that harassment is an offence. Sections 3 and 3a of the Act provide for civil remedies for harassment. We won't be going into that here. Subsection 7.3 of the Act tells us what the phrase course of conduct means. In relation to the harassment offence in subsection 1.1, the course of conduct must be on at least 2 occasions. In relation to the harassment offence in subsection 1.1a, the course of conduct need only be on 1 occasion, but could be on more than 1 occasion, of course. Finally, I need to mention that amongst the defences for a charge of harassment are that the conduct alleged to constitute the harassment was reasonable. This is in subsection 1.3c of the Act. All of this raises the question, what is harassment in law? That's difficult to answer because the 1997 Act does not define harassment and no clear definition is found elsewhere, and the courts decide these cases on the facts. But here I will go through some cases in an effort to find a meaningful answer. The cases I mention may be criminal or civil, even some employment law cases, as the jurisprudence on this seems to blend together. In the 2006 employment case of Majrowski and Guys and St Thomas's NHS Trust, the House of Lords judgment includes this statement: courts are well able to recognise the boundary between conduct which is unattractive, even unreasonable, and conduct which is oppressive and unacceptable. To cross the boundary from the regrettable to the unacceptable, the gravity of the misconduct must be of an order which would sustain criminal liability under Section 2. That's Section 2 of the Protection from Harassment Act 1997. In the same judgment, Baroness Hale made this observation: all sorts of conduct may amount to harassment. A great deal is left to the wisdom of the courts to draw sensible lines between the ordinary banter and badinage of life and genuinely offensive and unacceptable behaviour. In the 2001 civil harassment case Thomas and News Group Newspapers Limited and Hughes, the then Master of the Rolls, Lord Phillips, discussed the definition of harassment and stated, "Harassment is a word which has a meaning which is generally understood. It describes conduct targeted at an individual which is calculated to produce the consequences described in Section 7 and which is oppressive and unreasonable." The reference to Section 7 there is to subsection 7.2, which states, references to harassing a person include alarming the person or causing the person distress. What the judge is saying is that subsection 7.2 is not a definition of harassment. It merely describes the required effects of the offence. The judge is also saying that for conduct to amount to a criminal offence of harassment, it must be oppressive. In the 2013 civil case of Hayes and Willoughby, Lord Sumption in the UK Supreme Court followed Lord Phillips and described harassment as a persistent and deliberate course of unreasonable and oppressive conduct targeted at another person, which is calculated to and does cause that person alarm, fear or distress. Lord Pill, in the 2010 criminal case of Curtis against the Crown, again upheld the analysis of Lord Phillips in the earlier Thomas and News Group Newspapers judgment, and stated, to harass, as defined in the Concise Oxford Dictionary, 10th edition, is to torment by subjecting to constant interference or intimidation. The conduct must be unacceptable to a degree which would sustain criminal liability, and also must be oppressive. I think the reason for the judiciary's insistence that the harassing conduct must be oppressive for a conviction to ensue is that this serves to focus minds on the distinction between, on the one hand, criminal conduct, and on the other hand, conduct, however unpleasant, falling short of attracting criminal liability. The conduct must also be unreasonable. Lord Phillips in the Thomas and News Group Newspapers judgment went on to discuss the defence of reasonable conduct in subsection 1.3c. Whether conduct is reasonable will depend upon the circumstances of a particular case. Obviously, the remarks from Lord Phillips that follow are not directly relevant to the incident we're covering in this video. Nevertheless, these remarks are of interest. When considering whether the conduct of the press in publishing articles is reasonable for the purposes of the 1997 Act, the answer does not turn upon whether opinions expressed in the article are reasonably held. The question must be answered by reference to the right of the press to freedom of expression, which has been so emphatically recognised by the jurisprudence both of Strasbourg and this country. Prior to the 1997 Act, the freedom with which the press could publish facts or opinions about individuals was circumscribed by the law of defamation. Protection of reputation is a legitimate reason to restrict freedom of expression. Subject to the law of defamation, the press was entitled to publish an article or series of articles about an individual, notwithstanding that it could be foreseen that such conduct was likely to cause distress to the subject of the article. The 1997 Act has not rendered such conduct unlawful. In general, press criticism, even if robust, does not constitute unreasonable conduct and does not fall within the natural meaning of harassment. A pleading which does no more than allege that the defendant newspaper has published a series of articles that have foreseeably caused distress to an individual will be susceptible to a strikeout on the ground that it discloses no arguable case of harassment. It is common ground between the parties to this appeal, and properly so, that before press publications are capable of constituting harassment, they must be attended by some exceptional circumstance which justifies sanctions and the restriction on the freedom of expression that they involve. It is also common ground that such circumstances will be rare. Mr. PINAC QC for the respondent offered the example of the editor who uses his newspaper to conduct a campaign of vilification against a lover with whom he has broken off a relationship. Mr. Brown rightly submitted that this unlikely scenario was miles away from the facts of this case. He submitted that editorial comment would only amount to harassment if it incited, provoked or encouraged harassment of an individual. In summary, the points I would distill from all that are that for any conduct to be considered unreasonable in the context of journalism and justify sanctions from the court, it would have to be an exceptional situation in which either laws were being broken or the journalistic activity was without any public interest justification whatsoever. There must, let's not forget, also be a course of conduct. Returning to Lord Pill in Curtis against the Crown, he stated, "Assessment of a defendant's conduct for the purposes of Section 1 involves, of course, consideration of whether the conduct can be described as a course of conduct, but that course of conduct must be conduct amounting to harassment, as so defined. The two limbs are interrelated in that an analysis of a course of conduct, including the frequency of acts, may well throw light on whether it amounts to harassment." A useful summary on the relevant law is found in a 2010 civil case, Dowson and others and the Chief Constable of Northumbria Police, especially at paragraph 125 of the judgment. Mr. Justice Simon listed the points that should be present in order to prove harassment as a matter of law. There must be conduct which occurs on at least two occasions, which is targeted at the claimant, which is calculated in an objective sense to cause alarm or distress, and which is objectively judged to be oppressive and unacceptable. What is oppressive and unacceptable may depend on the social or working context in which the conduct occurs. A line is to be drawn between conduct which is unattractive and unreasonable and conduct which has been described in various ways, torment of a victim, or of an order which would sustain criminal liability. Point 1 there only applies to the harassment offence in subsection 1.1. The other harassment offence, that contained in subsection 1.1a, can be pursued after only one occasion. Also, point 2 was specific to that case. It is possible for a third party who was not the intended victim to pursue a harassment complaint or claim. The word oppressive tells us that the conduct must be harsh beyond a level that would normally be expected between people. Turning back to this situation at the Jewelers, Marti Blagborough and David Birdsall are accusing the staff member there of harassment. Given that this is one occasion, we will be looking at the offence in subsection 1.1a, which, to recap, requires a course of conduct which involves harassment of two or more persons, and which he knows or ought to know involves harassment of those persons, and by which he intends to persuade any person, whether or not one of those mentioned above, not to do something that he is entitled or required to do, or to do something that he is not under any obligation to do. Subsection 7.3 of the Act tells us that, in relation to the harassment offence in subsection 1.1a, the course of conduct need only be on one occasion. Subsection 1.3c of the Act tells us that a course of conduct will not be harassment if it meets at least one of the following defences. It was pursued for the purpose of preventing or detecting crime. It was pursued under any enactment or rule of law or to comply with any condition or requirement imposed by any person under any enactment, or, in the particular circumstances, the pursuit of a course of conduct was reasonable. Is the staff member committing harassment? Looking first at subsection 11A, the staff member and the security guard too are trying to discourage and dissuade Marti Blagborough and David Birdsall both from doing something they believe they are entitled to do, which is to record the premises and stock, and to do something they believe they are not under any obligation to do, namely cease recording the premises and stock. Looking back at Mr. Justice Simon's list, point 1 is not relevant because this is a subsection 11A offence. Point 2 states that the conduct must be targeted at the claimant. In this case, the staff member has not targeted Marti Blagborough or David Birdsall. He has a proper reason for speaking to them, which is that they are continuously recording the frontage and expensive stock of a city centre jewellers, and although they are doing so from a public highway, their behaviour is unusual and a source of concern, and anyone would have approached and challenged them in these circumstances. Turning to points 3, 4 and 5, which I think can be read together, is the staff member trying to cause either of them alarm or distress in a way that is oppressive or unacceptable? I think that has been answered by addressing point 2, which is that the staff member has a proper reason to speak to them. He isn't challenging them just because he doesn't like street vloggers or for some other arbitrary reason. Furthermore, we know from their online pedigree why Marti Blagborough and David Birdsall are there. They are there to get a bite, to provoke a response. Point 6, I think, is the death knell for any harassment argument. The staff member is not stood in Marti Blagborough's personal space. Marti Blagborough is lying about that to make the content more entertaining for his viewers, and the staff member is not continuously recording them, and his reasons for speaking to them are legitimate and fall within his duties as a staff member. Therefore, even if his manner is unattractive or even unreasonable at points, he is not doing anything that could be seen as criminal. But even if you disagree, I think this staff member's actions comfortably fall within at least 2 of the defences available in subsection 13C. He is preventing or detecting crime because a jewellers will obviously be suspicious of strange men filming stock, and in the circumstances this is reasonable. Furthermore, the security guard there also has those defences and can also say that he has the defence in B, that he was carrying out his licensable activities as an SAA licensed security guard. This includes recording both Marti Blagborough and David Birdsall, which again falls within his duties and is permissible under data protection for the purpose of site security and crime prevention. Now let's turn to the behaviour of Marti Blagborough and David Birdsall and ask whether they committed harassment of the 2 staff members and Berrys Group Limited, which I'm given to understand is the company that owns the shop. But even if that's wrong, the point is that it is possible to harass a business as well as a natural individual as long as the business is a separate legal personality, which would normally entail a limited company of some type. I believe the 2 auditors' behaviour comes under both harassment offences, that is subsection 11 and subsection 11A. Subsection 11, to recap, requires a course of conduct involving at least 2 occasions. The first occasion is them turning up to record, the second occasion is them uploading the recordings to their YouTube channels for people to watch, but that completes a course of conduct only if it is harassment. Turning to Mr. Justice Simon's list, the conduct involved here was on at least 2 occasions. The conduct was targeted because both Marti Blagborough and David Birdsall intended to visit that particular jewellers and target any number of staff there. The behaviour was calculated to cause alarm or distress, which is the whole point of the exercise, otherwise they would have boring footage that earned them nothing on YouTube. Was the behaviour oppressive and unacceptable? The behaviour involved turning up there with the intention of provoking a reaction, knowing that the staff of the jewellers were bound to want to speak to them, then provoking the reaction, refusing to stop and reacting obnoxiously when spoken to, and lying about the actions of a staff member, then uploading the footage and subjecting the staff members and the company to criticism and ridicule. Furthermore, Marti Blagborough on the 2nd of November, just gone, uploaded a clip from this 6-year-old footage to his Facebook profile, and it was a clip that focused on their conflict with this specific staff member. That Facebook post has, at the time I made this video, attracted 473 comments. It has to be said that many of the comments are critical of Marti Blagborough and David Birdsall, and rightly so, but many others support them and proceed to malign and pour scorn and ridicule of the staff member with insults and comments about his appearance, and I'm now showing you some of those comments. Is this the sort of thing that a staff member at a jeweller's should expect? I ask because we have to consider points 5 and 6 of Mr. Justice Simon's list, which is whether the conduct of the auditors was oppressive and unreasonable. I believe it was. The recording is continuous throughout the visit and is being done conspicuously to provoke a response. Being recorded at your workplace when carrying out your duties and having this broadcast online may cause alarm or distress if the recording was unwanted and not for a legitimate purpose, especially if the intention is to cast you in a bad light and encourage people to malign and ridicule you, which is exactly what happened. This was also intrusive and infringes privacy because it showed this man at his workplace, and having rebroadcast the footage recently, Marti Blagborough is bringing the incident up again. This man will have moved on with his life now, but he may have to face questions about it from his new employer or from family and friends and renewed embarrassment. None of this is fair or warranted because the actions of the auditors were never justified in the first place, and this man was simply carrying out his duties. I'm not suggesting a photographer or vlogger must always have a reason or justification for recording someone, whether it's a jeweller's shop or something else or some individual even, but if you go out to provoke people with a camera, that can never be considered legitimate, and often it will be an offence. This is not journalism, it is baiting and bullying, and I believe it is harassment and an offence. I will also say though that I don't believe the course of conduct described in subsection 11A is seen in this incident because while most of the elements of harassment are present, both Marti Blagborough and David Birdsall are stood on a public right of way, and I think that negates any application of subsection 11A because both sides of this are at liberty to stand there. There is no question about that. But I do think Marti Blagborough and David Birdsall were committing here harassment under subsection 11, and the course of conduct was completed when they uploaded their respective videos. The next question is whether Marti Blagborough has continued the course of conduct by uploading the footage again on the 2nd of November just gone, some 6 years later. My view is that he has. In fact, both David Birdsall and Marti Blagborough have uploaded multiple videos about this incident. Marty's last video about it before his 2nd of November Facebook post was 2 years ago, and it was the same clip as the one he has just uploaded to Facebook. And I think this practice of him and other auditors of re-uploading old videos and also videos that YouTube have taken down, as well as potentially being contrary to the platform's terms and conditions, could also be viewed as harassment in some cases. In this case, Marti Blagborough's intention in recently re-uploading the clip to his Facebook page is to cause alarm and distress to the staff members recorded. He is targeting them. In point of fact, he even revisited the premises shortly after his first visit.
Guys, welcome back to the rainy channel on a rainy day. But I'm here, guess where I am? I'm at Berrys for a round 2, let's check this out.
This second visit was clearly viewed as concerning by security at Berrys, who could see him recording the shop from a distance, and eventually he was approached by one of the staff. Marty thinks he's clever.
Yes?
Do you mind me asking what you're videoing, please?
I'm videoing you.
Why?
Because you just walked up to the front of the camera.
Yeah, but what, can I just ask why you're videoing the shop?
Because I want to.
For any particular reason?
To put you on YouTube.
That's very kind of you.
Yep.
Yeah?
Yep.
Will you crack on then?
See you later, you mug.
Marti Blagborough is charming, isn't he? A real credit to photographers everywhere. He's really advancing public photography rights and promoting goodwill towards photographers. Anyway, I'll now return to the original incident.
That is harassment.
This is all on CCTV.
You best take a foot back. You took a step in, take a step back.
You had breached his space by waving your hand.
Don't be silly. Shush. Shush.
Why?
I'd love to see
Shush.
Who's going to put...
You're talking about violence now. We're not talking about violence.
About violence? You were waving your arm in his hand.
Look at you.
Look at you.
Posting, I'll be putting the footage on YouTube later.
No,
so
that's not even funny.
Well, I will be.
So without written permission, I used to work for...
I will be putting it on YouTube and you cannot stop me.
I will say that the mistake the staff member made here was in prolonging the interaction with the auditors beyond what was necessary. As soon as it becomes apparent they are auditors, just withdraw and observe and report. That, of course, is applicable in a situation like this when it's a public right of way. I appreciate there are other situations when the auditor is actually also trespassing, and clearly that's different, and in that case the interaction does have to be prolonged and is a more complicated situation.
Your face.
For me now.
Your face is...
Again, I'm going to react. Watch.
What do you mean you're going to react?
Watch. Simple. I've just told you. Who do you think you are?
Who do I think I am? I'm just trying to do my job, but you're walking around.
What is your job?
Do you work out here? Do you work out here, yeah?
I work
You're
for
doing
the
your job in
building.
a public space, guys. You see this? Is your job controlling people taking photos?
And
That's not really the point. Of course you can't control what you do on a public right of way, but your behaviour is targeted at that shop.
the day you don't have the right to put out. We
Yes,
have
I do,
spoken to
and
you.
I
We're
am.
on footage.
Yes, I
You
do,
do
and
not
I
have
am.
our
Yes,
rights.
I do, and I am.
If
Yes,
I
I
find
do, and I
myself on
am.
YouTube, then we will take.
You're actually going to,
Do what? There's no offence, you can't do nothing.
two of us will do it.
Fucking side.
Again, the auditors are wrong. These staff members could have taken action, maybe still can, for civil wrongs, including civil harassment, misuse of private information, and breaches of data protection, and they could pursue privacy complaints on YouTube and Facebook. It's down to them and the company as to what course of action they take.
Very, very silly.
Tyrants, guys. Tyrants.
They're not tyrants.
And learn the law.
Learn the law, guys.
You both need to learn the law as well. Even after all this time, you're wrong about it.
I'm just going to take another picture now.
Well, how do you see that guy?
That guy, what an aggressive piece of shit.
You'll see that despite all the trouble, both of them continue to record the shop and conspicuously photograph it, ignoring the concerns and objections raised by staff.
We want us to be aggressive. But see, this is what you do with. This is why we're out here. This is why we're here today. Because people like that. People that think that they can control what other people do.
Where is he?
While
Some people would call what you've just seen the exercise of public photography rights. Personally, I think this activity is dangerous for photographers and their rights. It is weaponising photography rights to harass people. Marti Blagborough does try to justify his actions. This is on the basis of an earlier exchange with one of the staff which went like this.
Took a step in, take a
First
step
of all,
back.
you had breached his space by waving
No,
your
I
hand.
didn't.
So he had the
No,
right
I
to
didn't.
take it to the floor.
No, I
and detain
didn't.
you by
I'd
the
love to do it.
police.
I'd love to.
I can't comment on that because I didn't see what went on. It sounds like Marti Blagborough tried to provoke the security guard off camera, maybe trying to goad and provoke him into going hands-on.
Well, how do you see that, guys?
That guy.
He wanted to be aggressive, didn't he? He wanted to be aggressive. But you see, this is what you deal with. This is why we're out here. This is why we're here today. Because of people like that. People that think that they can control what other people do whilst in public.
As a general principle, people can photograph buildings from a public right-of-way without permission, and I hope that position never changes. But it might one day change due to the actions of people like this, who are using our photography rights as a pretext for bullying and harassing people.
Seeing that, guys? This is Berrys in Leeds. Berrys in Leeds. Apparently that's how they treat photographers, apparently.
I don't think Berrys or their staff did anything to deserve this treatment from you. You just pick on people.